Hello and welcome back to another video by the A-Level Law Teacher. Today we're going to be looking at intention to create legal relations, which is on the contract law unit and one of the formation of contract topics. One of the key things we're going to be looking at today is the importance of intention to create legal relations and the fact that you can have offer and acceptance, consideration, privity, all those other formation topics, but if there's no intention to create legal relations, then there's no contract. Most of this can be divided into two sort of sections. Firstly, business or commercial agreements where the courts presume that there was intention to create legal relations. And then also social and domestic agreements, otherwise known as between family and friends, essentially, where the courts presume that there was no intention to create legal relations and therefore there was no intention for that agreement to be a contract. So starting with business or commercial agreements, business agreements are presumed to be legally binding, so that there's a presumption that there is a contract, and that's the starting point. And it's up to the party who doesn't want a contract to rebut that presumption by proving that no intention existed. So it's up to them to prove that it wasn't meant to be a contract, essentially. In terms of AA3, the courts take this sort of a different view of business agreements compared to social or domestic agreements because businesses need certainty. They need to know that if they make an agreement, that it's going to be legally enforceable and that other parties very likely to do what they said they're going to do. And if they don't, and therefore this company makes a loss, you can sue for that and enforce that. So it's that real need for certainty. The courts aren't interested in bad bargains. So if you as a company get yourself into a bad bargain or a bad situation, a bad deal, you can't just get out of that deal by saying it's not a contract. And the courts don't like that, and they try and avoid that. Equally, it has to be very clear evidence is needed to prove that there's no intention when an agreement is business orientated. So if it is a business agreement, it's going to be very difficult to argue that there's no contract. You would need very clear evidence of that. In terms of cases, I've divided these into sort of two sections. Down the left are the cases to do with commercial gain, and down the right are the cases to do with wording of a contract. We'll go down the left first. So Carlisle v Carbolic Smoke Ball. Obviously, Mrs. Carlisle was using a smoke ball to try and cure her or prevent her getting the flu. And the company had offered a £100 reward if someone used it correctly and still developed the flu. So she tried to sue them. They said no. Well, she tried to claim the £100 and they said no. So she sued them. So they tried to get out of it several different ways. One way in which they tried to avoid paying her the money was by arguing that there was no intention to create legal relations. It was just an informal agreement, essentially, not an actual enforceable contract. And they said it was just advertising puff. They didn't really mean it, essentially. But the court held that there was intention to create legal relations, and this was particularly evident because they had actually put money aside and literally labelled it as to meet any claims. So they clearly had meant for it to be a formal agreement. Similarly, in Esso Petroleum v Commissioners of Customs and Excise, Esso, as petrol stations, essentially ran a promotion offering a World Cup coin collectible in exchange for buying a gallon of petrol. They then discovered they were going to have to pay some tax essentially on this, so they decided they didn't want to do that and tried to argue it wasn't a contract between them and consumers essentially. And the court held that it was. They were clearly making a commercial gain from running this promotion and making money, and there would be a very clear customer expectation in terms of receiving that World Cup coin if they bought that gallon of petrol. So in terms of protecting consumers, there was a clear need there as well. So the court held that there was clear intention to create legal relations. That's very similar to the case of McGowan v Radio Buxton. There was a competition. The prize was a car. The winner received a model of the car, 4-inch scale model instead. And again, the court said there's a clear commercial gain. They were running the competition to make money. It might have turned out to be a bad bargain for them, but that's tough luck. And there was a clear customer expectation. So clearly, again, intention to create legal relations. In terms of the wording of the contract, the court's approach generally is that if you say it's not a contract, then it's not a contract. And you can see that in the first two cases here, James v Vernon's Pools, where a winning football pool coupon said binding and honour only on the back. And the court held that there was no intention to create legal relations. Then, it said essentially saying that there's no intention for this to be a contract. Essentially, there's no intention for this to be legally binding. So therefore, it isn't. And that's the same approach taken in Rose and Frank v Crompton, where they said in the agreement this is not entered into as a formal or legal agreement. So the court held that that was not a contract. Jones v Vernon's Pools is a bit of an old case, the sort of arrangement of football pools, so the applicability of that today might not be as evident. And there's also some AA3 concerns around exclusion clauses, which we'll touch on later, with things like Rose and Frank v Crompton. In terms of Kleinwort, quite a complicated case. Essentially, the Malaysian Mining Corp was a umbrella corporation which over a company called Metals Limited, and Kleinwort were lending around £10 million to Metal Limited, and they asked Malaysian Mining Corp to guarantee that. So basically, if Metals Limited couldn't pay it, that Malaysian Mining Corporation would. They said, no, we're not doing that, but we will give you a letter of comfort, telling you that we think you can lend them the money, they'll be fine. Unfortunately, they weren't fine. They couldn't pay it back, so Kleinwort went after Malaysian Mining Corp, arguing that the letter of comfort was in fact a contract. And the court said no, it's not a guarantee. If they wanted a guarantee, they should have got one. That's what they did ask for and didn't get. So they said there was no intention to create legal relations with that document, for instance. There is a contrast case, though, however, of Edwards v Skyways. So Edwards v Skyways, the agreement was between an employer and employee around a redundancy payout, and it said ex gratia, which means goodwill, they would give this payment. So if you apply that to the same sort of style or precedent from Jones v Vernon's Pools, you would expect that perhaps then to be not a contract, but the court held that this was, so it is a sort of an exception case. I think that's particularly relevant because it was between an employer and employee, where that is an established legal relationship, and particularly about redundancy, which there are of course very strict rules on now as well. So, but nonetheless, a bit of an exception. Moving on, we'll look at halfway house cases. So this is where it's not quite clear whether it is a social and domestic or a commercial or business agreement, and these are quite difficult for the the courts to manage. So the judges are obviously going to have to make a decision as to where to start, what presumption to start with. And a key case here is Sadler v Reynolds, where it was between a journalist and a businessman. It was an agreement to ghostwrite an autobiography. They were friends, and obviously it was a business deal as well. So the court had to decide where to start, and they ultimately decided in the end that it was a contract. Similarly, in Snelling v Snelling, there was three brothers that wrote up a business agreement essentially, and then it was a dispute as to whether it was a contract or not, and the court held that it clearly was a business agreement and therefore was a contract, and it was sort of irrelevant, the fact that they were three brothers, because it clearly was about the business. So in terms of AA3 and evaluation, these sort of cases are difficult for the courts to manage, as there's no clear starting point, and the judge is going to have to do that, which then of course leads to more time and therefore more cost to the client. In terms of social and domestic agreements, the starting point is the opposite of business and commercial agreements. So in fact, in this case, it's that it's not a contract, it's just an informal agreement between friends and family. And therefore, the party who wants a contract, it's up to them to rebut the presumption that it's not a contract by proving intention existed. So they're going to need to prove that there was intention to create legal relations with this agreement, and therefore it was meant to be a contract. In terms of AA3, the courts aren't interested in petty squabbles. We know that the courts are already backlogged, and of course they're taxpayer funded, so we want to reduce clearly the amount of unnecessary cases coming to court. We'll touch more on that later with the AA3. In terms of cases for this, they can be split into sort of four sections: spouses and family on the left, and then friends on the right, in terms of the difference between casual and formal agreements. In terms of spouses, so domestic essentially generally means family in this context. There's two key cases. The first one is Balfour v Balfour. In this situation, it was a happy couple, and they made an agreement whilst quite happy that the husband was out of the country and agreed to pay his wife £30 per month. They then later got divorced, and the wife obviously petitioned to continue to receive that money. And the court held that there was no intention to create legal relations when that agreement was made. It was just an informal agreement between a husband and wife, essentially, and therefore there was no intention for that to be a contract. However, in Merritt v Merritt, there's a key distinguishing point here. The couple had actually already separated, and then the agreement to pay his wife an income was made. And the court held that as this was in contemplation of divorce when they were unhappy, essentially, that there was intention to create legal relations. So there's quite a niche point there that you need to be able to distinguish between, if you're looking at spouse cases, as to about when the decision was made and their sort of happiness of the couple when that was made. In terms of family, the courts generally take the approach that they're not interested in petty squabbles, and you can see that in Jones v Padderton, where an agreement was made between a mum and a daughter for her daughter to return to the UK and live in a house rent-free in exchange for her doing the bar exams to become a barrister. They fell out; she didn't pass the bar exams essentially, and she wanted to sue to continue to live there, and the court held that there was no intention to create legal relations with that agreement. It was just an agreement between mum and daughter, and not legally enforceable. However, in Parker v Clark, there was an agreement between two couples, an older couple and a younger couple, who were related, hence the sort of family nature of this. And the older couple made an agreement with the younger couple that they would move in with them, look after them, and then inherit that house. In exchange, they would, well, that's what they would do, and the younger couple would sell their property essentially, which they did, and gave up that security. They gave up the security of their house that they had, and they gave some of their money away as well. And the court did decide in this case that there was intention to create legal relations. It was a contract, particularly because that they'd given up this security. There's quite an enormous amount of security by selling the house and giving some of that money away. In terms of friends, the courts really clearly distinguish between casual agreements and formal agreements. So in Buckpit v Oates, it was a very casual shared lift arrangement. One person drove sometimes, one person drove the other times. They sometimes paid each other some money, but it was not really very structured and very casual. And the court decided that there was no intention to create legal relations. There was no contract there. Similarly, in Wilson v Burnett, it was a very casual agreement, a one-off chat before going to bingo, that they would split the winnings if they won. One of them then won and refused to split it, and the court held that there was no contract. There was no intention to create legal relations with that. They said that casual conversations can't be elevated into binding agreements. In terms of formal agreements between friends, though, these can either become contracts or can be seen as contracts. So in Albert v MIB, a single person for over 8 years drove two colleagues to work. There were very set payments. It was a very structured agreement, and the court held that this actually became a business agreement over time. So therefore, there was intention to create legal relations with that agreement. Similarly, in Simpkins v Pays, it was a structured agreement around entering competitions between a few people. So one person always did it, and there were structured payments again to facilitate that. It was a regular arrangement thing. So the court held again there was intention to create legal relations. So the key difference when you're looking at friends is the sort of casual versus formal nature of those agreements and the sort of structure of that. In terms of some scenarios here, Bob and his friend Alan regularly entered golf tournaments together and split the winnings. They entered a tournament where the prize money was £10,000. Bob won the tournament but refused to give anything to Alan, advised Alan on whether he can insist on half the prize money. There's quite a nice structure you can do with these in terms of identifying the type of agreement first, so the fact that it's a social or domestic agreement, as Bob and Alan are friends. Therefore, the presumption is that there's no intention to create legal relations, and the onus or responsibility would be on Alan to prove that there was intention to create legal relations. It's up to him to try and demonstrate that he is owed this money, and therefore it is a contract. Now, as this is a regular structured agreement, and you could compare that to Simpkins v Pays, it says that they regularly enter golf tournaments and split the winnings. Alan is likely to be able to be successful in proving there was intention to create legal relations in this case. It's different. You can distinguish this from the case of Wilson v Burnett. It's not a casual one-off chat, clearly. So it's likely that Alan would be able to insist on half the prize money. Similarly, in this scenario, Samantha runs a local shop. She wants to sell more bottles of water, so she makes a poster advertising a free chocolate bar if a customer buys 6 bottles of water in one purchase. Nadia buys 6 bottles of water, but Samantha refuses to give her a chocolate bar. And then it should say here, advise Nadia on whether she can insist on being given the chocolate bar. So clearly this is a business agreement, as this is an agreement between a business and a consumer or customer. Therefore, the presumption is that there is intention to create legal relations, and the onus and responsibility would be on Samantha to prove that there was no intention to create it. It's up to her to demonstrate that it wasn't meant to be a contract, essentially. Now, as she's making a clear commercial gain from the deal, and Nadia would be expecting to receive the chocolate bar, very similar to the case of Esso Petroleum v Commissions for Custom Excise, or Radio McGowan v Buxton. McGowan v Radio Buxton, it's very likely that Samantha wouldn't be able to demonstrate strong evidence that there was no intention to create legal relations, and therefore Nadia would be able to insist on receiving that chocolate bar. Now, finally, intention to create legal relations is an potential essay topic, so you do need to be aware of quite a considerable amount of AO3 to be able to evaluate this topic in an essay. So I'm just going to whiz you through some of these key points here. The first key one is freedom of contract, the idea that you should be able to form a contract if you want to, and have that be legally enforceable, and businesses obviously really need that, which is a point we'll look at point number 3. But it's important that you're able to do that, and the courts facilitate the rules for you to be able to do that and treat them as legally enforceable if you want them to be. Equally, they have to draw a line somewhere, and they clearly don't want certain cases certain agreements being viewed as contracts, particularly between family and friends and things like that. That leads nicely on to point number 2, which is the courts aren't interested in petty squabbles between family and friends. That would open up the floodgates to a ridiculous amount of cases coming to court, which would clearly be unnecessary. We know the civil courts are already backlogged significantly, taking years to hear cases. And of course, they are taxpayer funded, so that would increase the burden on the taxpayer in terms of paying for those cases, for the judge, the courtrooms, etc., when that money could be used better somewhere else in terms of education, NHS, armed forces, etc. Certainty in business is absolutely key. We've already touched on that today. It's really important as a business that these are presumed to be legally binding, any agreements, because you need that certainty, that you need to know that the other party is very likely to deliver on what they've said they're going to do, so you can rely on that promise. And if they don't and you make a loss, that you can sue for it, and that's going to be really key to investment and to be secure that you can invest the money because you know that you're going to get this money back, etc., in terms of growth and therefore the impact on the economy and all of us. And equally, the courts aren't interested in bad bargains. They very treat businesses, it's up to you to manage your risk. So therefore, if you make a bad decision and make a bad bargain, the courts won't allow you to just get out of it by arguing that it's not a contract. In terms of protecting consumers, the court's approach very much is that they need to protect consumers and look after them, stop businesses abusing their positions. So stopping that sort of feeling of being conned. You can see that very clearly in cases like Adesso Petroleum and McGowan v Radio Buxton. And that links very nicely to Consumer Rights Act and stopping businesses taking advantage and making financial gains unfairly. In terms of wording, the courts take a really clear approach, as you see, as we've seen, is that if you say it's not a contract, then it's generally not a contract, and that's good for negotiation. It allows parties to obviously put various agreements out without them necessarily being seen as contracts unless they want them to be. But there is a risk, of course, of dominant parties abusing their positions there to put exclusion clauses in and say they're not contracts when really they should be. So that is also a sort of a major risk, and something actually picked up by the Unfair Terms Regulations 1999, which said that all exclusion clauses have to be reasonable. It could be argued that an exclusion clause saying that this is not a contract might not be reasonable, but that's never been argued in court, so it's unlikely, given that they're in 2020s now, that that's going to be the case. There's certainly no precedent on that. There's also some inconsistency between some of the cases. If you look at Edwards v Skyways, for instance, where it said out of goodwill compared to James v Vernon's Pools, you can see there's clear inconsistency in the cases, which can make it difficult for legal professionals to advise their clients in preparation of cases for that. Halfway house cases are obviously very difficult for the courts to manage in terms of where the starting point is, the presumption is, and that's going to add time and therefore cost to the client in terms of arguing that in court. Similarly with spouses, what is a happy versus unhappy relationship? How is the court judging that? How is the court judging as to when someone is in contemplation of divorce and whether an agreement is made in contemplation of divorce? And that arguably could be seen as sort of a sexist approach to the idea of, if you look at a lot of these cases, it's men agreeing to pay women incomes and things like that. So there is a view amongst some that as to why can't that, if they're making an actual agreement about money, why can't that be a legal agreement? Why can't that be a contract? And equally, we can see that in the sort of rise of prenups and the courts taking prenups very seriously in terms of them being formal agreements. And that's in contrary to the sort of view of cases like Balfour v Balfour, where they say, well, that's not a formal agreement, yet you can make a prenup, which is a formal agreement. Again, largely historically protecting men would be the sort of argument around that as well. In terms of number 8, issues with family members, again, you've got some inconsistency amongst cases like Parker v Clark and Padavon v Jones in terms of, what does giving up financial security look like, and the inconsistency that can cause by not having exact clarity on that. And very similar issue with the sort of agreements between friends, what actually makes an agreement structured versus a casual conversation. There's no exact clarity on that, which of course could lead to confusion and time wasted in courts. But equally, it does fit certain arrangements, like things like lottery syndicates and stuff, where clearly there is intention to create legal relations there, and therefore that should be protected. Just because they're friends, essentially, it's irrelevant. Finally, this is an area of common law, so it obviously raises the obvious issues of separation of powers and parliamentary supremacy. Most of contract law is of course, common law. It's been set out for hundreds of years and very unlikely to change for that reason, really. There are statutes and regulations that obviously we've looked at, Consumer Rights Act, unfair terms regulations, for instance, but there's no overall legislation setting out the rules of intention to create legal relations. So that clearly could be a reform suggestion in terms of legislating and creating a statute on that. However, given that this area of law is so old and has been developed ad hoc and sort of over sort of a patchwork approach, case by case, over many hundreds of years, it's unlikely that there's going to be any political appetite to legislate on this. So that's the end of the topic. I hope you found that useful today. Please subscribe to the A-Level Law Teacher channel. That'll help to develop new videos, and there should be some more videos on contract law coming out very soon. Thank you very much.